problem here is that we have a co-trustee who the beneficiary trustee does not like, and he clearly does not like her. If you read these pleadings, these people hate each other. He hates her, she hates him. They apparently are rude to each other. They both cite instances of great hostility that's demonstrative. So you imagine these scenes that are happening. And now, let me make a prophecy here. Millions of dollars will be spent in this dispute.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
So welcome to another episode of Life's Third Act. We're talking about Jimmy Buffett. I encourage you, those who've not watched the first two episodes, to do so. You know, we talked about his life in that, primarily in the first one, and his family. And then in the second one, we got into talking about his estate planning and some of the decisions that were made there and why they were made. And then today we're going to be talking about where some of those things went wrong. Now, we've already discussed some issues relating to trustees and whatnot, but this becomes especially ugly now, and now there's litigation. So we just had to do 3 parts in order to cover this subject. But it's incredibly interesting, and I think you're going to learn a lot. So come aboard. I mean, I get it. Jimmy left this and left provisions, and if her lifestyle, which that's one of the standards for her needs, is her lifestyle, if she needs $5, $6, $7, $8 million a year or more, I mean, why can't the trust throw off 5%? I mean, 5% is what, $12.5 million or something, or more than that? Yeah, I mean, I have to tell you a heads up in terms of where I land on this, is that it just seems that, why is this so necessary? You don't have competing interests of other beneficiaries from the language that appears in this will, especially. It just doesn't appear that Jimmy's priority was to assure we got to save money for the kids.
Yeah. So
I'm wondering, why is this happening? And so what this leads to is the conflict has gone on for a while, since 23. And so 18 months or so they've been arguing. And then finally, I don't know what spawned the actual filing of the lawsuit. The wife says that let's call him Richard rather than Mozenter, that Jane says Richard knew that she was going to file something in California, so he filed something in Florida, which is what he did file something in Florida the day before, I think.
So what can she do is there a way to get rid of this guy?
We don't know that yet. I'm going to move through this quickly. You're asking a very good question, because that's kind of what it's going to come down to.
Okay.
So petition to remove the personal representative. This was filed, one of the items that was filed in Florida in Palm Beach County. This was filed by Richard, and he's wanting to get rid of her as the personal representative of the estate, which is problematic for him because the person who's in charge of the estate, meaning the things that were not in the trust, she's in charge of that. She's the one who's the PR, the personal representative. So there are assets there that presumably are going to end up in this trust, but it's all held up now because she's not closed that estate. But her argument is, I'm not getting the information I need to close the estate from you, Richard, as well as other things. So he's filing a motion to have her removed as personal representative, saying she's not doing her job to get the estate completed and closed. And then he also files, though, a complaint for her removal as co-trustee. When I first read this, I have to tell you, I thought, it sounds like he has a pretty good argument here. I'm going to just hit some highlights here. Remember, these are all just allegations. Whenever you read from complaints that are filed in court, this is not proof. This is not evidence. It's allegations. Now, the allegations are made under penalty of perjury. They have to file they sign this under oath, a notary, inscribed, et cetera. So it is something that they could be charged for perjury if you file something with courts that you know is not true. Anyway, but that doesn't change the fact they're allegations. They're not proof. So here's why this is long. So, I mean, I'm just telling you, it's fun reading. It's like a National Enquirer sort of thing. So he makes all these accusations against Jane, how crazy and unreasonable she is. He says that during his 30-plus years, Rick, in addition to his firm, Gelflin, Rennet, and Feldman acted as Jimmy's business manager and financial advisor. So now that I read the way this is worded, Rick, in addition to his firm. So it comes back to what we were saying a while ago. I think Rick may have come along recently. Recently meaning several years recently. Jimmy repeatedly expressed his concern to Rick regarding Jane's ability to manage and control assets. So the position that Rick's taken is Jimmy knew that she couldn't manage or control assets, and he didn't want her to be in that role. He needed me to do it. And he says, for these and other reasons, Jimmy was very careful to create the trust in a manner that precluded Jane from having actual control over the trust. But as I explained to you, there are reasons for this to be worded that way that had nothing to do with his confidence in Jane. And it was Jimmy's clear intent that an independent trustee, in this case Rick, have the ultimate control of the assets. Well, to the extent that that's true, one could argue it's necessary that it be true, that he have the final word. So that doesn't, for reasons that would not necessarily mean Jimmy didn't have confidence in her ability to manage assets. Jimmy required that an independent trustee must always serve and gave Rick in his individual capacity the right to change independent trustees and appoint successors. He did do that. Other than serving as non-controlling trustee, Jane has no ability to manage the trust. This fact has made Jane very angry. As a result, Jane has repeatedly acted in a hostile manner and has been completely uncooperative with Rick in his attempts to administer the trust. Further, Jane has done nothing to contribute or share any responsibilities and has cost the time, money, by interfering in matters despite being asked many times to abstain from doing so. Apparently, she interfered in this separation agreement with Jimmy's boat captain, and that resulted in a dispute over the severance agreement. And so, according to this allegation, the trust had to pay out more money because of her interference. We don't know the details of that. Jane also forced out Jimmy's longtime law firm and estate planners. Jane's actions regarding this firm caused a significant amount of additional legal expense. Additionally, Jane forced Jeff Smith to decline to act as successor trustee in the event that Richard resigns for any reason. Mr. Smith was specifically named by Jim to replace Rick in the event that Rick could no longer serve. These actions are consistent with Jane putting her interests above fiduciaries. I don't see that. Anyway, further, Jane has consistently refused to engage or meet with Rick, acting in his capacity as co-trustee. I mean, there's no doubt Rick has some good points here, but again, we don't know all this stuff that I'll read to you from these two documents. We just don't know their allegations. Jane has repeatedly directly threatened to remove Savannah, Jimmy and Jane's oldest daughter, who's 46, as a remainder beneficiary of the trust. This is completely contrary to Jimmy's intent and wishes. He wanted Savannah to remain an equal remainder beneficiary of the trust. Well, remember, they're contingent beneficiaries because there may be nothing left at the end.
Mom could spend it all and those kids get nothing.
Yeah, or she could give it all to charity.
Yeah, that too.
During his lifetime, Jimmy, through the trust, made loans to Jane's family, which includes a note secured by a mortgage. Since becoming co-trustee, Jane has unilaterally instructed her family members to not make the required loan payments that are due to the trust. There's a breach of her fiduciary duties as trustee. Well, it might be. It might be a breach if that were true. Mm-hmm. You know, if it does impair the trust and it's an obligation to the trust, if a trustee does that, I'm talking about her wearing her hat as a co-trustee, not her hat as a beneficiary. Then, yeah, that would technically be a breach of their fiduciary duty.
And I'm not trying to be devil's advocate, but perhaps this was put in place too because there was that separation in their marriage. Maybe there was some money matters there.
Yeah, but that was so long before. Yeah, that was so long before, though. So, yeah, another paragraph in here, dealing with the removal of trustee of the trust. That's what he's wanting as the relief in filing this with the court in Florida. Pursuant to Section 7306, blah, 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 a co-trustee may request the court to remove the trustee and list various things. A serious breach of trust, I'm sure he alleges that. He does allege that, or due to the unfitness, unwillingness, or persistent failure of the trustee to administer the trust effectively. So his argument is, look, there's basis here to dump her and she should be dumped, and she should be removed from being the trustee of the marital trust. Remember, those are two separate trusts. Her lack of cooperation, her refusal to communicate with Rick substantially impairs the administration of the trust. So these are his allegations. I'll tell you, when I read this, I thought, this is reasonable. Again, I didn't know all the provisions of the trust because the trust was attached as an exhibit to his petition. So I read his complaints, the petition first, and then at the back of his complaints was the trust. So then I read the trust, and then I thought, well, the things I thought before about, I supported what I was reading in this motion because I thought that Rick, the independent trustee, I thought that he had some pretty good arguments. But then I read the trust and I thought, well, but the primary concern seems to be the beneficiary. Why would you be, what I assume is working really hard to preserve these assets for somebody else? I just don't, I'm not sure what he would say in response to that. But anyway, so after that, the attorneys in one of our California offices, I think it's the Sacramento office, they managed to get this. So it was like 2 days later that I got the petition that was filed by the wife. So I hear Rick's side first, and then I get Jane's side. And of course I read the trust, and I have to tell you, I'm thinking that Jane has a very good argument here. Let me go through. First of all, Jane, in terms of putting more juice in the punch here regarding her allegations, my gosh, I thought that this was pretty lurid and interesting. Not lurid, but pretty interesting. But I have to tell you, when I got to hers, I thought Rick has nothing on Jane in terms of the ability to put together interesting facts and whatnot. So this document is the petition now, and lawyers watching this would appreciate this more than the rest of you. Often a petition cites pretty mundane stuff, and a little like a will often does. This, man, oh man. So I'm not going to even touch all these allegations here because I said a few minutes ago I was going to try to do this in 15 minutes. I may have reached that already. So let me move quickly. So first there's a discussion here. This is filed, by the way, in L.A. County. Let's see, Superior Court of the State of California for the County of L.A. So here again, this is Jane Buffett, and she's filing this action against respondent Richard Mozenter, managing director of Gelfin, Rennert, and Feldman, LLP. And it's seeking to remove him as co-trustee of the marital trust, which is what she's primarily concerned about. And then the preliminary statement talks about the dispute rises from the ongoing failure of Richard to act in the best interest of Jane Buffett, the widow of world-renowned, beloved musician Jimmy Buffett, in the administration of the marital trust created for her benefit. Over the 20 months since the death of Mr. Buffett, the administration of the marital trust was done by Mr. Mozenter, a professional accountant who serves as a trust independent co-trustee, and Jeffrey Smith, the lawyer selected by Mr. Mozenter to represent the trustees of the marital trust, has been plainly deficient. So what that means is, as the independent trustee, Richard hired a lawyer to represent the trustees against, I guess, the world or vis-a-vis the beneficiaries. But it's kind of a bit of a fiction because really it turns out that he's aligned himself with one, it appears he's aligned himself with one trustee over the other. We don't know. All we know is what allegations are made here. Mr. Mozenter has failed to perform even the most basic tasks required of him in this role of co-trustee, including providing Ms. Buffett with information concerning trust assets and finances, which has left Mrs. Buffett in the dark with regard to the state of her own finances. Along the way, he's belittled, disrespected, and condescended to Ms. Buffett in response to her reasonable request for information. He's been paid enormous fees, more than $1.7 million in 2024. To him and his firm. I mean, I don't know whether that's reasonable or not. I mean, certainly it would be expensive to be able to manage a trust like this with lots of different assets of different kinds. But $1.7 million. Given such persistent conduct earlier this year, in February 25, Ms. Buffett's personal counsel wrote Mr. Mozenter a lengthy letter that cataloged his many failures and demanded that he correct them. Months later, he still has failed to do so. Mrs. Buffett asked that Mr. Mozenter resign as co-trustee. He refused, insisting that he remain in a position of authority over her wealth. The situation is untenable, and she requests the court assistance to resolve it. So during his lifetime, Mr. Buffett had a close relationship with the accounting firm. I read you this. This is the name of the person that he had the actual close relationship with that was employed with this same firm, Gelfand, Rennert, and Feldman, and that was apparently with Erwin Rennert, one of the named partners, an accountant at that firm. So that was a person who, according to these pleadings, that Jimmy Buffett had the long-term relationship. So when Mr. Buffett amended the Declaration of Trust, however, he named as co-trustee Mr. Mozenter, a younger accountant at the same firm who had not been as close to the Buffett family. So by appointing Mr. Mozenter as his successor trustee, Mr. Buffett trusted that after his death, Mr. Mozenter's primary regard would be the best interests of Mrs. Buffett. And it's clear that Buffett in the will, if I didn't make that clear to you a while ago, he wants the focus to be on her. He specifically states that he wants her to be the primary concern, the primary beneficiary, that her best interests predominate any other consideration.
She's taken care of.
Yeah. So again, it's very clear what Jimmy Buffett's priorities were. Mozenter accepted the appointment as co-trustee, taking on the responsibility of managing $275 million in assets that Mr. Buffett had amassed to fund the marital trust for his wife's sole benefit for her lifetime. That's true. She was the sole beneficiary during her lifetime. 1 month after Mr. Buffett's death, October 23, she met with Mozenter and requested an analysis of projected income that she could expect to receive from the marital trust. So I'm sure she and her accountants, wanted to know, based on this, what can we expect the payout to be? And I'm reading again. This should have been a simple task for a professional accountant paid to administer a marital trust specifically created for her benefit, but it proved not to be simple for Mr. Mozenter. Rather than help his recently widowed client understand her finances, he spent the next 16 months stonewalling and making excuses for why he could not yet provide the requested information. Then on February 25, Mr. Mozenter finally provided an estimate of projected income and expenses, and they were shocking. According to his projections, the marital trust, $275 million in assets, would generate less than $2 million in net income annually, a rate of return of less than 1%. Mr. Mozenter acknowledged that over the prior 18 months, Margaritaville, a company of which the trust, it owns roughly 20% of that enterprise, had paid distributions of $14 million.
But she's only getting what?
So the trust gets $14 million
She gets $2
of income, and why would that's income, right? I don't. But based on that analysis, Mr. Mozenter told Mrs. Buffett that the marital trust income would not cover her annual expenses and advised that she could consider adjustments to those expenses or sell her own real estate to make up the difference.
I mean, that's stressing her out. She's, again, used to that lifestyle and not being able to actually touch the money.
But I'm telling you, when you read all this from Mrs. Buffett, Jane makes some pretty good, reasonable arguments here. Again, these are allegations. This is not proof. But these are her allegations. She filed under oath with she signed and with the notary and was filed with the court. So it goes on and on. So I can't continue here, but it's pretty shocking, the level of conflict that had developed here and the allegations that are made between them and how this attorney that was hired to represent the trustees ends up, it appears that he's aligned himself with one trustee against the other. And again, all we know is what we read here, but it doesn't look good. And it's just, this is how things can go really wrong. And if you think about it from Jimmy's standpoint, it wasn't obvious here that this was going to be a train wreck. I think that probably the real red flag to him should have been the idea that somebody was being appointed he didn't know. And his wife apparently didn't know. So as we look for what we can learn here, one is to take out money into a separate trust and don't end up with this competition between a life beneficiary and a remainder beneficiary. Now, there are times when that is appropriate, but for many couples, if you have a lot of money, just go ahead and take care of your kids. Don't end up with your kids fighting your wife because they think that she's spending too much money. And so you end up with litigation, especially where it's a stepmom, but even when it's not a stepmom. So you don't want to put them in that position. And there is a way to do that. If you think there's enough assets for the wife's care, if there's enough, and that's one of the reasons it's not done, is that there's not enough. So they have to say all the assets are available for her needs and then what's left for the kids. But when there is enough, you go ahead and take out money and set it aside so you create independent trusts. But in this case, it was different from that. That wasn't the problem here. The problem here is that we have a co-trustee who the beneficiary trustee does not like, and he clearly does not like her. If you read these pleadings, these people hate each other. Yeah. He hates her, she hates him. They apparently are rude to each other. They both cite instances of great hostility that's demonstrative. So you imagine these scenes that are happening. And now let me make a prophecy here. Uh-huh. Millions of dollars will be spent in this dispute. Yeah. And I think most of it is going to come out of the trust. But this is,
it's a shame. So it's unnecessary.
A shame. And I just feel like if I were the trustee here, I'd be very interested to hear Rick's argument. But when you have a case where you have one beneficiary and clearly is if not the word sole concern of the settler, the person who created the trust, clearly the primary concern, and one could even say sole concern. I mean, whenever you say that she has the right through power of appointment or whatever to give the assets all to charity, it sounds like sole concern, even to me, though he loved his kids. He took care of them, though. I mean, he gave them money, as we talked. Just a very small fraction, and we don't know why he chose to do this way. But anyway, he did. That's the way he chose to do it. He could have set it aside for him. He didn't. So if I'm the co-trustee here, the independent trustee, I mean, my inclination would be to accommodate the person that Jimmy cared about. And that the person who created it cared about. But again, I think this may come back to it's somebody who wasn't involved early on.
He's looking at it more as a business, perhaps, instead of like real people.
Yeah.
And when this goes to court, if she does win and he gets bumped out, then is it just her, or is there always going to have to be a co-trustee? There
will be. There needs to be an independent co-trustee for the reasons I mentioned. So There's got to be an independent. But that doesn't mean conflict. Heaven forbid. That role would disappear if this were the story whenever this is used. It's not the story when it's happened. Matter of fact, this situation in this form is fairly unusual because in this case, the Jimmys of the world pick somebody that they know is friendly to the wife that they really care about. I mean, Jimmy cared about Jane, so he wanted somebody who was friendly to her, and typically. And so I think that's where things went wrong. But maybe Jimmy couldn't imagine a world where somebody would not want to pay out everything they legitimately could under the terms of the trust to her. And let me mention one other thing. I know I've gone beyond 15 minutes. Is that there's a jurisdiction issue here. I think that she's going to be able to have this case in California. We'll see. But normally where the trustee holds their primary offices, where they're to be found, where the records are kept, et cetera. And it appears that for this firm is L.A., which is where I think she is.
She's in New York. He's in L.A.
Okay, so she's in New York living primarily. So anyway, but she chose to file in California, which I think was appropriate. He filed first, and he filed in Florida. So I think her arguments for jurisdiction are better in California, and I think her result might be better in California too. The courts have the discretion to replace a trustee, and for what we mentioned a few of those reasons a few moments ago, And there's another basis that is cited in this petition that wasn't mentioned in the petition that was filed by Richard, and that's that she's saying, look, I'm the only beneficiary. So if 100% of the beneficiaries agree, and it's not inconsistent with a primary purpose of the trust, and I think that's clearly true. In my opinion, it's clearly true. Then I think the court on that alone is going to be inclined to grant it. But there are other bases where the communication is so bad that it impairs the ability of the administration of the trust, where there's serious and grave fiduciary breach. I don't think that's going to be found on either side. I think what she's doing, she's not trying, it doesn't sound like a serious breach of fiduciary duty, and nor does what he's doing sound like a serious breach of fiduciary duty. That's like where it's dishonesty or, some
sketchy.
Yeah, something that is improper, self-dealing, self-interest, that sort of things. I don't think any of that's happening here. I think a little bit of this has become ego. Again, I don't know. Obviously, I don't know these people.
Well, and two, I can't help but feel bad in one way for her. I'm not trying to pick sides, but she's probably in her 70s.
Yeah.
Because, Jimmy passed at 76, and you think about she doesn't need the stress. Yeah. She's in her golden years.
She shouldn't be going through this. And one thing that's telling to me is among the allegations made or the complaints made by Rick in his petition was that she was rude to him and she was disrespectful and that, quote, she treated him like a bookkeeper. So, I think that's pretty telling. I think there's ego here. And once you have somebody who is in a very big role, but they think in a very small way, it's a prescription for trouble. If he's so small that he allows that to affect his role in such a grave responsibility, $275 million of assets, that's not, you don't want somebody who carries their ego on their sleeve, and if the person that they're serving offends them, then suddenly they're prepared to have the whole thing go up in flames or at least create a lot of problems because they're offended. Again, I don't know this guy, so he could be the nicest guy in the world and have no ego, but I'm just reading what he said and I'm reading what she said. But again, we don't know. All we can do is form our opinions based on what information we have. So I hope that this was interesting to you. I know we went a little long here, but there was a lot of meat. And I think there's just a lot of things to learn. And if you watch this entire thing, you know a lot more about trust than the average person. And you've also learned a lot of things that are useful to you, even though you don't have $275 million trust. A lot of these principles I just described, if you have $500,000, they apply.
Yeah, it could happen to anyone. This kind of dispute within a family or, if you have that co-trustee.
Yeah, that's right. So, all right, this has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.